go through this very critical bill on behalf of the people of Jamaica and the workers and employers. Give us the knowledge, wisdom, and understanding to come to consensus so we can move as we seek to get this work done. These and other mercies we ask in your most humble name. Amen.
Amen. Thank you, Senator. Next item, apologies for absence. I'm told that Senator Webber has sent an apology for his absence. Well, any other apologies? So we may proceed. All right, let me welcome you again to this another sitting of our Joint Select Committee, duly appointed to consider the Occupational Safety and Health Bill. We are set today to continue with our clause-by-clause analysis, and I see we have here joining us today the representative from the JCTU, Mr. Grant. Let me welcome you, sir. Yes. The PSOJ is represented here, and as well as the Employers Federation. And the committee, Mr. Grant, felt that by virtue of the nature of this bill and how far-reaching this bill is, even at this stage, it is important to have the workers' rep, employers' rep, and the invitation was also extended to the PSOJ. So I want to welcome you, and do feel free to participate in the discussions, so long as you indicate that you have something to say, you will be acknowledged. So welcome again. Members, before us today are two sets of documents from the Ministry of Labor and Social Security, one dealing with Part 14 of the bill and the other dealing with Part 15 of the bill. We acknowledge that we are in receipt of these documents, members. There is also a document, a letter from the Attorney General's Chambers dated July 6th. Members, do we acknowledge? Yes. And there are two other documents that will be relevant for the afternoon session, dealing with the two different groups that were asked to, yes, seropositives and the Gasoline Retailers Association. The gasoline retailers have indicated their unavailability for today. They have proposed a further date, however, but we will deal with that when we get to that stage. But we have the brief from the seropositives. Yes. So, any other matter, members, before we get into the business of the day?
And
Chair.
Any minutes for the records that we need to just collect?
Well, I know that minutes have been prepared. It is just a matter of them being circulated, and then among ourselves we'll decide the convenient date for the taking of these minutes.
I assume, Chair, that the clause by clause include the schedules.
Certainly they will. Whether or not the ministry is prepared to take us that far today is a matter for them. But I know, even based on the guidance that would have been provided by CPC and the AGs, our discussion at this stage must include the schedules. So, ministry, I believe, we are now ready to take part 14 of the bill. Based on where we stopped on the last occasion, we are now ready to take on clauses 209 to 218. Yes.
Good morning, members. Good morning,
Yes.
legal
Ms.
team.
Michael. Yes.
Yes, Minister. First, let me apologize for Mrs. Campbell. She'll be a bit late. She had a little emergency. Sorry, as extending apologies for Mrs. Campbell. She will be a little late. She had a little emergency this morning, but she'll be joining us shortly. We pick up from clause 209, part 14. That's the general section of the bill, which deals with obligation for secrecy. And we have proposed a deletion of the section as it obtains and to be replaced with language similar to that in the Information and Telecommunication Technology Authority Act of 2019. We looked at clause 209 and recognized that the secrecy, the obligation for secrecy that is being contemplated is, among other things, information that would have been gathered during the investigation, or rather the carrying out of the authority's function, such as a trade secret, for example. And so we believe that the legislation needed to contain information protecting any disclosure. But 209 as it stands, we believe, do not capture our intent. And so section 17 of the Information and Communications Technology Authority Act of 2019, we are recommending that words to that effect be contemplated in the legislation. If I may read section 17 of that legislation, it says any person who has an official duty or is employed in the administration of this act shall regard and deal with as secret and confidential all documents and information relating to the functions of the authority obtained by that person in the course of the performance of that person's duties or otherwise. Subsection 2 says a person to whom any information is communicated, including information contained in documents by a person under subsection 1, shall regard and deal with the information as secret and confidential, except to the extent otherwise provided in any other law. The obligation as to secrecy and confidentiality imposed under this section is in relation to any document or information under this act, continues to apply to a person notwithstanding the person having ceased to have an official duty, ceased to be employed or otherwise concerned in the administration of this act. Now when you look, you will notice that this provision is a bit wider in provision than that in the OSH bill. And in fact, if you look at clause 209(2) and 3, it appears to be limiting what the legislation that are to be covered. And so we would not want to limit, just in case there are other areas or laws that may not have been contemplated.
Any comment from CPC or AG in that regard? Members? So we are adopting.
We will adopt it, Chair. ICT Authority Act, we 2019. Is this a recommendation from the other government legal thing, or this is something that
Well, the ministry
Labour
has put forward a proposal which has been circulated to the legal teams. I've seen the comments from AGC. They have not disclosed any difficulty with this, the proposal that the ministry has put forward. CPC also has indicated just now, Member Brown, that they have no difficulty with what the ministry is now putting forward.
my effort to find the source of this wisdom is not being assisted.
Well,
I had concern about 2092, but it is covered in this new formulation. But I was trying to see why this formulation just dropped out of the air into this.
I believe that
What is the effort that brought us here?
the new version, the new provision, well, I think Ms. Michael has indicated, but I'll just allow her again, as to give you the reason as to why the new version is put forward. Ms. Michael?
Since we have been at this joint select, there has been a number of changes, numerous changes that have been made to the legislation, to the bill. And we have been sitting among ourselves, the ministry team as well, and we consult with the other legal teams to determine how the best approach. So the ministry, in looking at this provision, recognized the weakness, and we have been looking at recent legislation as it deals with particular provisions that are similar to what is contained in the clause. So when we looked at the ICT, we saw that it is all-encompassing when you compare it to what we have in the OSH bill, and so we thought it was something that would improve the bill. Thus, we made the recommendation, which was sent to the legal team for feedback and response.
Since some research has been done, can I ask how many other legislation you consulted or research which has within it a secrecy and confidentiality clause? How many other legislation that have secrecy and confidentiality clause?
Many others. When we, for the last few years, the problem with this draft is that it would have been, although it says Act of 2017, the draft was prepared sometime before that. The secrecy provision was a bit dated, since what was put in and I'm not talking about the subsections 2 or 3 now, just 2091. It was dated. Since that time, there have been a number of laws, so MOCA, Integrity Commission, fisheries, any of the more modern, I would say, acts that establish a statutory authority for the last 3 or 4 years would have had an updated secrecy provision that would have gone a little further to indicate that the employee, well, when the person is no longer employed, they still have a duty of secrecy. Because before, the older provisions only said that while you're employed to the authority or whatever entity, you have an obligation of secrecy. The more modern ones go a little further.
The ex-employee carries for life that obligation.
Right, and it's done for certain laws because of the nature of the information that you will get. nature of the information, usually private information. And again, it is something that we thought would accord better with our new Charter of Rights in terms of privacy.
You don't mind thinking.
So any of those sort of entities like Integrity Commission, like MOCA, where persons who are employed in an official capacity and acting in good faith in the course of their duties would see all this kind of personal, private information. And I think it's also it's probably in either the TAG or RAA Act as well, that this obligation for secrecy goes beyond the employment.
I'm trying to see if there's a time frame. Age 24, I'm an ash officer. I go into a bakery. And sir? No, bakery today. And so I discover, I got information. Age 54, 30 years after. That's a secret I must keep. In other words, there's no time limit on the secrecy.
No, Member Brown, there are other ways for persons to get access to information without an employee or former employee having to reveal it. So, for instance, there is an Access to Information Act that can be used.
Yes, Member Gill.
When I looked at 209(1), particularly A2, I saw it as being vague, very vague indeed. Just a cover in terms of the intent. And 3 is speaking to, how you treat with an obligation to secrecy and confidentiality imposed under the section. And I went back to page 101, clause 149, the specific powers on entry, where, it requires any OSH officer, any person to tell the OSH officer the name and persons who has custody or have access to documents. And I recall us having a discussion, I don't remember if it was that particular clause, but it was a particular clause that gave reference to the confidentiality in terms of certain evidence or documents that may be presented, and how would you would have the protection of those information, especially if it was generic in nature. And so I can appreciate what this new 209 is seeking to do in terms of protecting the confidentiality of documentations or important information that would reside in a business. So I have no difficulty, Chair, in accepting what is being presented, especially if it was used in any other piece of legislation. And taking into consideration also that when this particular clause was drafted, it would have been way back when.
I'm almost sure that if we look at the genesis of the ICTA bill, it might have preceded 2017, but that's not important right now.
No, but just
That's
I'm
not
sorry.
important.
No, just to say, Senator Brown, you do touch on an issue, which is that there are times when we do have inconsistencies with our provisions. So I'm looking at JACRA, and the provision, the secrecy provision is different, and that's a 2017 bill. But we are now trying to make an effort to make sure that everything is now aligned and that we have consistency in our provisions. And if we don't, it should be because there is a deliberate intention for there to be an inconsistency because of the nature of the bill. But there is an issue in terms of making sure that all the provisions are consistent. So for instance, one of the things we're trying to do is make sure that the definition of document is now consistent throughout all legislation, and we are using as our standard what's in the Evidence Act. So it's going to be a slow process. So it is true, you're going to find provisions in different acts that may say something slightly different. There are times when it's deliberate, but there are times when it's just really an oversight.
Yeah, coming and taking off from the official Secrecy Act and so forth. There are different classifications of secret, confidential, etc., etc. Using secret and confidential in this, is there a reason for the difference for having both of them?
Those two terms are actually in JACRO, secret and confidential, that people must treat with it. Because in government, and it's not just even in Jamaica, even in England, you will see that because, again, to take into account the varying classifications of documents. So you may have had some that are regarded, because secret is the highest classification of documents. Things that are secret are generally all cabinet decisions, for instance, and cabinet submissions, and some of the appendices to cabinet submissions, depending on what the appendices are. And that is also sort of fleshed out in the Access to Information Act, because in the Access to Information Act, they say that if an appendix or cabinet submission, I think, is dealing with just purely factual things, very factual details, then I don't think those fall in the secret category. I could be wrong, but I don't think so. I think those would be more confidential. There is easier access to confidential documents than there is to secret documents. I suspect also that one of the reasons, I can't tell you because the terminology, you'll find it in even older laws where it spoke about treating or having regard to secret and confidential. It perhaps is because of the terminology even with the Official Secrets Act, which was amended several times, where they wanted to make sure that everything that you deal with, whether secret, whether confidential, is covered, and that you know that you are not to disclose it without, say, a court order or other legislative reason.
For purpose of this act, what is secret and what is confidential? I understand cabinet submissions and so forth. Because you walk into a workplace, I think dash officers need to know what is secret, what is confidential, and I, the public, member of the public, need to know which of the information I give is secret, which is confidential, if any of them, if they fit any of those classifications.
Ministry, you wish to come in here?
Member Brown, I'll allow the ministry to answer, but I don't know if the ministry has also taken the time to classify all the different types of documents they will get, because remember now we're dealing with documents that will be submitted to the ministry, or not the ministry, to the OSH officer, to the authority. The authority will have to have its own classification of documents, and it will have to decide what they treat as secret, what they treat as confidential, and the different tiers. Right now there is not just a RIM policy, well, the RIM policy in government that has been developed over time, and it started when we were developing the Access to Information Act, and I know it will also be further enhanced because of the Data Protection Act. So you have not just MSET, but you have the Ministry of Education and Youth Information working on it, and they are encouraging all the different MDAs to develop classification, and I know this because we are also in the chambers trying to do this as well. And so the ministry, because it will be the role of the ministry right now to have to assist before the authority gets off the ground, to determine the types of information that will be sent to them, because you remember there will be reports, returns, and all of that. They will have to look at the types of information sent in and then determine how they classify all that information. But I mean, the ministry can also give you further information.
Here is where I'm having a concern. So I'm an employee at a particular organization that might be under either investigation or inspection. And based on the provisions contained in this particular clause, I must provide some information that is either secret or confidential or general in nature. Now, it is a requirement as an officer of that organization to provide such information. And I know it may be administrative in nature or operational in nature, but how am I going to be satisfied that I am protected for this obligation in the future when an issue may arise? Because I am compelled under this particular clause or others to provide the information. But I want to be satisfied that as an employee who my designation is to provide the information, then later on I am protected.
So it's not covered anywhere? It says it return page.
Yes.
So the ministry also indicated that they would be using a provision that they got from, I think, FID Act.
Yes.
So it allows you, it authorizes at the top of page 2. So
Yes.
it will authorize persons to disclose in certain circumstances, like court order, if you are required to under the law. So if you were acting in good faith and in accordance with this law, then you wouldn't be subject to any prosecution.
That is so, yes. Member Longworth, you wish to comment?
Thank you, Chair. Good morning, everyone. Just probably out of my edification here in terms of what Senator Brown highlighted with secret versus confidential, how is directly medical treatment regarded in that manner, if there is a reference to it? And is there any, again, like I said, it's more for my edification here where I'm ignorant of what probably exists, but provisions towards health matters that may arise later, or infringements on a employee that may not arise immediately, but sometimes even decades later. How is that treated with?
Yes.
Well, once it's a criminal offense, you don't have a statute of limitations. So if the person divulged information that they did not have the authority to divulge, then they can be prosecuted. So health matters. Now, in terms of whether they are secret or confidential, I don't know how the ministry is going to classify them, but at the very least they're confidential. All medical records, any information relating to, and in fact, generally, the rule of thumb is that you have to go to a court. If it's not given, if you don't give consent, if it's about me and I don't give consent, someone else who wants it has to go to court. And it can't even be divulged under access to information either.
And also just to let you know too that within health records, the mental health records are even more confidential and cause for extra provisions. So I just want to make sure that that is being kept in mind.
No, Mr. Basker is just reminding that even throughout the bill, remember when we were going through, we would have had provisions that said the information, medical records cannot be disclosed unless the person consents, and the only way it can be disclosed is if it's done in a way that it doesn't identify anybody. So it's in a more generic statistical kind of information. But generally, on top of the fact that we are now putting in this provision that will say that it's an offense if an employee who gets the information divulges it in a manner not contemplated under the law. There's also a civil aspect of it because it's a breach of right to privacy. And you will recall that our Constitution has not just horizontal rights, but vertical rights. So it means that it's not just that when you have a constitutional breach, you can claim it against the state, you can also claim it against somebody else. So there are different levels of protection that are provided for with this rubric.
Mr. Warren?
Just a clarification.
Okay. Yes, Mr. Warren.
Thank you, Minister. Seeking some clarity on this proposed substitution of Section 17 into the Act. I hear the posture about the ATI that can be used as well as a court order to get to this information. But I would like to hear how would the PAAC get its footing to get this information? Would it be a court order too? Or is it somewhere housed that it could?
Yes. Are you referring to the Committee of Parliament, Mr. Watt, the PAAC? I will, Soldier, I'll seek your advice in this regard.
I'm not sure why the PAAC would want to get someone's medical records, because that's what we're kind of discussing, the personal records. And I don't know that PAAC usually ever ask for. Right, appropriations are usually financial matters, not matters that relate to anything personal, such as medical records. I'm trying to understand, but in any case, witnesses, there are privileges of witnesses when they appear before committees of Parliament. So if somehow, perhaps maybe if it's in relation to some kind of business financial record, because remember PAC really deals with financial matters. So let's say it is something dealing with a PCBU. Because remember, the reports to Parliament are usually, to me, especially with the authority, it's going to be done in a more general way. But if for some reason, I can't imagine or understand why, but if for some reason there is some issue that could, where the PAC is requiring certain documents, witnesses have privileges under the standing orders, and also that's fleshed out in the rules of common practice at the House of Commons, England, where you can even request a private session if the information is going to be detrimental in any sort of way to like a business or commercial interest. But I don't see how that would really arise for this, because the kind of reports that this authority would be submitting would be, let me use the word, sterilized in a certain way.
Sorry, Minister, I wasn't referring to medical records. I thought this was about general operations of the authority. And if this is about medical only, my apologies.
Mr. Secretary?
In terms of what is considered secret or confidential, I hear the Sunjel said that the ministry will determine. But I just want to know for consistency and a standardized approach. How will the employee be aware of what documents are secret/confidential, and where in the bill will treat with that particular categorization? Because it can be after the facts, then you say they were, and is it through orientation? So I want some clarity, because if I'm to protect these documents, then it must be clear up front from both employer and employee that these documents are so categorized based on the authority's own definition. So I'm not clear in the clause, and I don't know if it has to be in the clause, but where will that standardized approach be had right across different workplaces? So it can be secret for A and confidential for B. So what is confidential for A is considered secret for A, and vice versa. So I'm not clear as to how that categorization will be so determined.
Ministry, but before you come, I'll just ask Soljan to speak on what is the common practice in this regard, whether it is that it forms part of the bill or whether the ministry thereafter will have a duty to notify persons up front.
It's a very difficult question for me to answer. What I would say though is, no, it is not something that's usually that we put in the legislation. It isn't. Ministries, departments, agencies are authorized to come up with their classification of documents. But as it deals with secret and confidential, that's something that the guidance comes from Cabinet Office, as I understand it. So there is really supposed to be a consistent application throughout government, which is why earlier I said, even though I know this is an authority, the ministry would have to have their input and perhaps give this guidance to the authority. Further, as I indicated earlier, there are some policies that are being developed now by ministries that are supposed to assist each MDA in terms of the classification of their documents. But when it comes on to things that are secret or confidential, usually that comes from Cabinet Office, as far as I understand it.
A quick follow-up. I'm not afraid with all the provisions in the Communication Technology Authority Act. Does it have any guidance in there as to what definition for secret / confidential? Because we are using it as our reference and we're inserting this provision.
Right, but we don't know. But in the laws, we don't define secret and confidential. So
it's based on the ministry, the cabinet?
So what the rules of construction tell you is these are terms of art. If you can't find the term of art meaning, then it means you just use the ordinary dictionary language of what is secret, what is confidential. But from an administrative perspective, throughout MDAs, there is an understanding of secret and what's confidential, and that guidance usually comes from Cabinet Office, as I understand it, and then it's supposed to be applied consistently across government, which is why I think the further policy development that is going on now, coming from Ministry of Education, Youth and Information, will assist MDAs in ensuring that there is consistent application throughout.
We're imposing on the populace, Chair, a condition that we don't even know what it means. And we're hoping that later on the ministry will define what it means. Let me ask this. There's an accident at Factory A. Among the fatalities is the female manager, age X. Age X is disclosed. Is that a breach of confidentiality? Is that a breach of secret? In other words, some information will get out and has to get out. How do we determine now whether or not the officer who spoke to the media, or is it maybe the officer shouldn't have spoken to the media, should have left it to the director? But how do we determine what is confidential, what is secret? So the employee, I'm trying to protect the employees, having revealed that information. Somebody writes and says, well, you breach secrecy or confidentiality, because it ought to have known before. And I don't know.
But just to say, so when it comes on to the public sector, basically everything we deal with is confidential. And the only authority we have to disclose any information is under the Access to Information Act. And under the ATI Act, it reminds us, public officers, that if we act inconsistent with the Access to Information Act, we are bound by and can be held liable under the Official Secrets Act. It's not going to be a similar thing for the stat bodies. So I am sure that what happens, as happens with most other stat bodies, that they actually sign a declaration when they are taking up their employment to say that they are going to regard everything they deal with as secret and as confidential, and that they can only communicate that information in a manner consistent with their law. I don't think this is a difficult thing.
So, Jen, in 2020, I'm frightened by the fact that government, public sector, is a shut-mouth business, and we have the Protective Disclosure Act, which is ineffective, but whistleblowing.
And we also have the Access to Information Act. Senator Brown, don't dismiss, though, the operations of the Access to Information Act. You'd be surprised.
No, I'm not dismissing it. I'm just simply saying.
You'd be surprised how effective that piece of legislation is. So it's not that we are saying that government is just all very closed and tight-lipped, but there has to be a way in which we regulate how persons' information will be getting out there, because remember, the authority will now be accessing a lot of information from employers as well as employees. And so this information has to be regulated. The manner in which this government and every other Commonwealth jurisdiction does it is, you have things like the Access to Information Act. You have things like, and now on top of Access to Information, we now have tried to complete the circle with our data protection bill as well. And when that comes into full operation with our ATI Act, with our Protected Disclosures Act, I don't see that there should be any major cause for concern.
The MAJ seems to have, through the chair, the MAJ seems to have some major cause for concern. The Media Association of Jamaica. No, I wasn't on that committee. I spoke in the House and in the Senate. And so there are concerns out there about things. And to hear now that government is really tight-lipped, a tight-lipped arrangement, it's frightening in the 21st century. And so it's something that we probably need to look at. I'm not going to pursue it anymore today. I believe what is clear is that there's need for guidance centrally from the cabinet as it's being proposed to be done. And the country needs to know what is secret, what is confidential, least of which the workers need to know what is secret and what is confidential and what information is general. In other words, can you disclose the age of a lady who might have been a casualty or a fatality in an event? Is that secret? Is that confidential? And if you tie that to our famous data protection, maybe we're shutting the door in an Orwellian way.
Dr. Robinson, I recognize you. Yes.
Thank you, Chair. Just adding quickly to Senator Brown's point, as well as for my own edification, but it would appear that for this bill, all secret documents seemingly are confidential documents. And if that is the case, if I'm correct, then would it be redundant to say both? And if not, are we separating them because there's a chance that we may be treating with them differently? That's the point.
Yes, Mr. Grant, O'Neill Grant.
Thank you, Chairman. As a substantive public officer, but I represent public officers as well, I recognize what Senator Brown is saying in relation to protection of workers. And I also do recognize too that as public officers, there is an obligation that we have to keep our work confidential and secret. And the staff audits and the public service regulations do not give us the latitude to expose our work. But there is also the protection that the workers need on the other side, if they are in the workplace and some act befalls them. And as a workers' representative, we need to present their case for compensation, that there are certain reports that we want to have that may be deemed secret and confidential that we should not be able to access. And it will stymie our ability to represent those workers properly. There's also some emergent case law, and I see reference being made to the I think it was the Criminal Investigations Act, if my memory serves me right, where the Dale Austin ruling in relation to secrecy and confidentiality would now change the complexion of how we treat with those matters. It may be tangential in terms of what we are discussing here today in terms of occupational safety and health, but the treatment of the material that is uncovered during the course of any investigation or work by a public officer at times may be required to support a representative of the worker when we are putting forward a case. Now, it is something that I recognize in the amended or the suggested amendment. It is to remove the obligation from the individual to make the declaration and to place that obligation, my own interpretation of it, at the foot of the organization or the ministry or department that is responsible for the investigation, rather than having it laid at the feet of the individual who did the investigation. And there is where I would agree with I would have some issue with the issue of persons who have left the service and them being able to be called on to give evidence. I would want to agree with the legislation that they should not be called on multiple years after the event has taken place to give evidence. The organization and the records that it keeps should be able to give and support whatever claim is being made by any individual arising out of an occupational safety and health issue in the defined place of work. Those are my comments, Chairman.
Yes, Sergeant.
Just to clarify, the last comment that was made just now, this obligation of secrecy does not apply when it comes on to matters before the court, which is what is being alluded to at the top of page 2. It's just that the ministry did not type everything out, so it wouldn't. The obligation for secrecy is only in relation to persons who are connected or employed to the administration of the act, and those who are employed or otherwise connected with the administration of the act will have to treat with matters as secret and confidential. However, they will be allowed to deal with the information as they need to carry out their functions. So there would be nothing to prevent them from performing their functions. And that is a part of the secrecy provision. It just was not, the entire thing was just not set out fully by the ministry on pages 1 and 2. But that is part of the normal, we're not doing anything different, Chairman. This is a normal provision that is in several laws across the land, and this is how it is always operated for years now. So it does not impede or interfere with anybody who is carrying out their functions properly, which is why I've been careful before to say once the person has been carrying out their functions in good faith and in accordance with the act, they cannot be prosecuted. They cannot be prosecuted. And just in terms of a matter that was alluded to as well, the Dale Austin case, when it comes on to matters that refer to you, again, the information can be disclosed to the person, as well as there was a court order. And again, this refers to the fact that there can be a court order that can allow for the divulging of the information. Again, that is there at the top of page 2.
Chair.
Sorry.
I think we might be seeking some guidance, maybe just a little bit of research from the technical team to guide us as to the full delineation between the secrecy, confidential, etc., confidential matters and what is what. So I mean, I wouldn't want us to be not given due discussion, but I think we're getting kind of caught up with something that we could maybe progress to something else and get more information on. But just also to add that by definition, and I've just looked it up, if this helps in any way, confidential is intended to be kept secret. Intended to be kept secret, whereas secret is not known or meant to be known or seen by others. So it would seem that, and I'm sure the forebearers who crafted this nomenclature would recognize that confidential, it maybe is a tier below, so to speak, and, you know, when you put them together now, you mean that, yes. So I think we can seek some guidance.
Yes, Ministry. Any further comments before we proceed? Yes.
Just check both Mr. O'Neill Grant and the Soldier raised the day lasting case. I'm a bit familiar with it. I know. But that's a case in which a member of the health team was terminated and he challenged for wrongful dismissal and won his case. One of the few times that wrongful dismissal gets supported in the court. We know there's a judgment on Friday that also went that way too, but yeah. Just to confirm.
Ministry, yes.
Good morning, everyone. I think the Sergeant has really captured, in essence, our intent. And as it relates to a practical example of secret, from time to time we may be doing our investigations. For example, an accident occurred, and we may get footage of that accident. And the process in that factory is one that they have copyright, trademark. So they would not want that information in terms of the process to be disclosed because it has implications for them in terms of their competition. So in terms of trade secrets, these are some of the things that we would have been contemplated in terms of trying to ensure that we are not disclosing information that can affect a business in that manner, but that would not impede us doing our investigation.
Ministry, in respect of subclauses 2 and 3, could you comment on that? And then I'll just ask the committee to adopt 209 as put forward by the ministry.
Yes, we were asking for a delete because we think the redraft that we did would have captured this. This was just too specific.
Very well. So members, we agree to the new format for 209 as put forward by the ministry. Yes. All right. May we proceed to clause 210? 210. So member...
Requiring redrafting 209.
Yes, 209, yes, in keeping with the section 17 of the Information and Communications. And
the subclass 2 and 3, which
that is so in keeping with section 10.4 of the Financial Investigation. Yes. 210?
Yes, we are of the view that this clause is unnecessary and should be deleted. It actually... Yes, when we look back at this clause, we thought it was unnecessary because it was basically saying all expenses for giving effect to the act should be defrayed out of the consolidated fund in relation to the USH officer. We did not think it was necessary in the first instance, and we certainly don't believe it's necessary now in the context of the authority to have a provision like this.
So we are asking for a deletion. Members, any comment?
My deletion was saying that we
removed it absolutely.
Moving 210. But when Mr. Sealy Brown draft the establishment of the authority, the funding will be there. So it's not, I would
yes,
getting rid of the consolidated fund. We're putting another part of the bill.
Okay, very well. So we are so advised by Mr. Sealy Brown. So we agree to that, members. Proceed, Minister.
We're also asking for deletion of clause 211. It was speaking about returns, reports, and other information. We do not need this clause. It was really meant to capture annual returns. But because of an amendment we made in relation to registration of establishments, we do not need this clause. And it did not really capture our policy intent.
Members, any comment? Yes.
Just to say that, when we're making reference to why there was a deletion, If a small statement could be made as to the reason, and not just to say to us, this clause is to be deleted. Just give us a small rationale or reason in the indication, so that when I'm referencing, I can remember why. Please.
And link it to whatever different.
Yeah.
Duly noted. Any further comments on clause 211 as we move to have it removed from the bill? We so agree, members? Yes. Ministry proceed 213.
No, I believe based on the comments here that AG had a comments about 212.
Yes. Let's proceed. 212, yes.
No, the AG had comments about 212, so I'll defer.
AGs? 212.
Morning, Chair. Morning, members. Clause 212 dealt with the general offences provision. Now, we did some work in terms of looking at the clauses in the bill to see what clauses provided for offences and if there's a penalty provided. And we found that there was no other provision in the bill that did not have a penalty. So on that basis, we were suggesting that that clause be revisited, since there are no other offences in the bill for which a penalty has not been provided. So basically, all the penalties have been covered in the bill. So we question the need for a clause like this, since you already provided for all the penalties.
So you propose a deletion?
Well, it's a matter for the ministry, really. I don't know if when they're doing the revision, if things might come out or they may decide something may be general. But what we found is that there's a general tendency to move away from general penalty provisions because of the risk that you could have an offense that doesn't merit the penalty that is prescribed.
Except, through your chair, except Mr. Basco, it goes beyond the act. It says every person who commits an offense under this act or the yet to unknown regulations. That is my editorial.
Yes,
but it speaks to regulations.
But if you look at 213.5, that's page 129, which generally deals with the regulation making power, it does provide for you to impose those penalties. So it's really a question of do you actually need it when you also treat with that same issue in a separate clause of the bill?
But my bigger issue with 212, and it also comes back at 213.5, is this: the Parliament will make these penalties. Yeah. We're going to give the minister some powers through regulations to make penalties, some of which may be harsher than what we in the Act, we gave in the Act. And I'm a little concerned about that. But not complaining with your point about they may be not defined. There's nothing that is not defined. My concern is going to be about the power of the minister to make regulations that may be even more powerful than that which the Parliament and a whole made, albeit affirmative resolution as in 213.4. Yeah, but we know that affirmative resolutions can't be amended. It has to be withdrawn. And therefore, as a parliamentarian, I'm not about to cede to a single minister the power to make more strident penalties, for example, than the 81 hours. What are the numbers? 21 and 84? 84 hours. That power that the 84 hours have. Because resolution that comes to the House can't be amended. And that's my concern. I don't want to give whoever the minister is.
All right. I see we have now gone to 213. Yes, but Sergeant, you wish to comment on the Member Brown? Yes, well, he was speaking about affirmative resolutions, yes.
Yes, and affirmative resolution means it's debated. But you get the opportunity to discuss and debate. But as it relates to 212, the issue only is whether you'd want to retain a general penalty for 212 when right now all the penalties are provided for. So, right. So as it relates to 212, that would be the discussion, the decision that the committee has to make. I was just making a remark, though, that it has come to our attention. There is a law. I haven't checked it myself yet, but I understand that there is a law that there was no penalty provided for a specific penalty, and there is no general penalty, which means there really is no penalty. So this is why sometimes we always say, you have a general penalty out of an abundance of caution, but when we checked through, we didn't see any need for it. So I'm just giving you the full context of how you look at a general penalty.
You know, when workplace rules are made, as a trade unionist, we usually contend that an employee must be aware of their scope of permissiveness. And penalties must always be prescribed. And it's difficult at times to challenge issues where there are no established penalties, that you're not aware of the prescribed penalty. And so I never normally like clauses like these that somebody can make up as they go along what deems fitting at the particular time. If the bill is consistent with prescribed penalties, then let us proceed along those lines.
Ministry?
Yes, the clause was actually there out of an abundance of caution, but we would prefer, if when we have finished the complete bill and the redraft, that all penalties are addressed, then we would take it out. Because the bill is still a work in progress here.
No.
But at this point in time, I believe there are penalties for most of the offense, but we have been introducing new provisions, policy. So we have to revisit all of those to make sure that everything is covered, and then we would suggest this provision to delete.
And before you members careful, how do you reconcile, Ministry, 212 with 213.5 based on what Mr. Basco has indicated?
No, but 212 was dealing with where there's no special penalty put in the law or the regulations, right? Right. 213.5 is saying that when you're having a breach of a regulation, you can impose a penalty in a parish court of a fine not exceeding $1 million. But as Mr. Basco, I believe, was pointing out, I think this
is there any difference between the two provisions? That's 212 and 213.5.
It's giving the parameters of the penalties 213.5. It's giving
because of the amendment to the Interpretation Act. The Interpretation Act Section 29 was amended in 2017, and it now allows for the fine went up to 2016. It was 2016. 1 million. It is now. So it used to be $1,000 if you didn't provide for anything in the law. Regulations could not exceed $1,000 or 3 months, and it was increased in 2016, and early 2016, to say $1 million or 3 months. So
yes.
No, so the issue is if you want to say more than a, but it's not so simple. If you want it to be more than $1 million, what are you contemplating? Are you going to be your regs? It should not be too open-ended either, because we do have those concerns, especially because it's a parish court. So you would want it can't be just that you want it to exceed. And in any case, you wouldn't write this now because of what's in Section 29 of the Interpretation Act. You wouldn't talk about not exceeding $1 million. But it's been an issue that has come up before about making it open-ended. And it's something that Senator Brown was alluding to. And I know the discussion, it happened, I think, in both Houses of Parliament when we were looking at proceeds of crime as well. And having it a little too open-ended. And I think that is something that you should consider. So it really would depend on what are the offenses in the regulations and what sort of penalties you would want for them.
Very well.
Mr.
Yes.
Chair, I want to take a different view. I heard that it was put here as a general provision. And the minister said we want to keep it and then to ensure when you go through the bill, all the offenses, there's a specific penalty. I am saying when you go through the bill, we need to ensure that. But don't keep this just in case. I prefer you delete this to force you to ensure that all the offenses, there is a penalty. So you don't miss none. And then in the debate in the house, both houses, if you miss, then you can always amend. But we don't want to have a general bill, and then when we go through, we keep it. So we have, if all the offenses have a penalty, then there's no need for this general provision. And when we're going to do the redrafting, I'm sure the technical team will go through in a specific way to ensure that that is achieved. So I would recommend from now, if we don't like this clause, which I don't like this general provision, then we delete it and ensure every offense has a penalty when we go through every clause that should have.
CPC, Mrs. Cedar Brown.
Because I really don't put it in a bill if every single provision provides for a penalty. I don't think we should keep it if all of the provisions are going to expressly apply for penalties.
Mr. Chairman, I also agree. I think it's, as I said before, I think it was just like a just in case. I don't really like just in case we miss something, we have this to kind of, no, I wouldn't say oppress, but then we would have this to say we can fine you. So I think what was said by the ministry to just let us just wait, look at all the provisions that's made, and then we can possibly delete it to make sure that everything is in the bill.
Very well. Ministry?
Yes, what we'll do, we'll pay careful attention in terms of the new policy items that were introduced to make sure that there are penalties for all. So we'll try to be careful in looking at that.
No, you're proposing that we retain the clause.
Yes, in relation to
No, I'm trying to understand what the ministry is saying.
No, I'm saying
fine,
based on
yes.
what the committee has told us,
Okay.
we will look carefully then to make sure we have not left out any.
Very well. So
Okay,
we
we'll
are
put
for the
penalty
deletion of
for
the clause.
everything. So we will
Okay,
delete
very
the
well.
clause, and based on what the committee says, be careful what we're adding in, that there is a
Okay.
penalty.
Very well. So members, we move to delete 212. Yes.
Chairman,
Yes.
this bill has to go through another process of redrafting. Am I correct? It is the view of the committee that all penalty clause must be identified in the Act and not be left out. That's my reading of it, and I hope I'm correct.
And you're correct, Member Brown. That's our understanding too. Ministry 213.
Well, we were asking for a redraft just to simplify the provision and to make it narrow to how provisions are actually addressed in this jurisdiction. So it is to be redrafted, that subclause 1, to specify that the minister may make regulations generally for the proper administration of and giving it, for the proper administration and for giving effect to the provisions of the Act. Without prejudice to the plurality of such provisions, the regulations may make provisions for the matter set out in the 9th schedule. So in this bill, the approach that was taken was to set out the make regulations in the 9th schedule in terms of what you can make regulations for. And then also throughout the bill, though, you will see as prescribed. So I will leave it up to the drafter because, yes, I heard the Sergeant. It's normally in the body of the bill, but I'll be guided by the drafter if they want to go, what approach he wants to take in this one.
Mrs. Seeley Brown, let us hear from you.
Chair, this can't work. Cannot work. No, yes, we have to put these provisions in the actual section that provides the regulation making power.
Okay, yes. Very well. So you are looking for the repositioning of clause 230.
Schedule. Yeah, we'll just delete the 9th schedule, and whatever is in the 9th schedule that we would keep, we would place it in clause 213.
Very well.
Yes.
Very well.
And this appears to be a drafting issue.
That's the point.
But we know 1 out of the 10 schedules will go. So we'll have to discuss that later.
Very well.
But the concern again I have is there are bills, there are laws which set out the regulation making power of ministers. Isn't there one that we could simply copy? Just as we copy the information and communication thing?
Yes.
I'm sure the Parliamentary Council office
Mrs. Seeley Brown, any comment?
Templates on these?
Yes, she will get back to the committee in that regard, Member Brown. In respect of subclauses 2 and 3, Ministry?
Maybe of general or limited application? What does that mean?
Well, I see here the Ministry has for it to be deleted. 2 and 3, that's where I was going, but I was advised that the entire clause will have to be redrafted. So.
But as much as it's being redrafted to accommodate in certain relevant parts of the 9th schedule, because when you look at the 9th schedule, I'll have to say relevant parts of it there. But I think the committee still needs to decide on
2 and 3 and 5.
2, 3, 4, right.
And 5.
Right.
Yes. All right, members.
On 1A, for example.
Yes.
213.1A.
Well, I think the ministry
that allows the minister to make a new law.
I think the ministry had already asked for 1 to be redrafted, Member Brown. 1 for me includes all of 1. Whether 1A, 1B, 1C.
I understand that, but the point I'm making is that in light of what the Sergeant just said, we must redraft with a view to making sure that the minister acts in accordance with the Act and the regulations are made under it. And so I did say there are likely to be legislation existing, and they are, with the regulation making power.
Making powers.
And we need to look at those to see how we fit this, because certainly 9th schedule is a whole heap. And when you add to that 214, you begin to see some powers given to the Minister Lambert Brown of Labour. You couldn't take that, David, right? So we have to make sure.
Well, I think, Member Brown, I think what Mrs. Seeley Brown is saying.
I wanted to get David one's attention in this.
Well, he was trembling. I think, yes, so the drafters have so advised that there are other precedents and they will be guided by those precedents. Yes, Ms.
And I just want to say that we had specifically asked for 2 and 3 to be deleted.
Yes. Okay. So members, subclauses 2 and 3 of 213, what is before us is for those clauses to be deleted. And Ministry, I know that AGC has raised 4 and 5. So while the members contemplate the request of 2 and 3, you may need to look at 4 and 5 so you can. Members, we move to delete 2 and 3 of 13 subclauses 2 and 3. To redraft, yes. So we delete 2. Yeah. Well, I'm waiting on the advice of CPC and AGC. Yes. So it's to be deleted, to be redrafted? So to be deleted for redrafting, yes? 2 and 3, yes. The entire clause, which is what we had agreed first, yes. So, yes.
What is the intention?
Well, yes.
Yeah?
Deleted and substituted.
And substituted.
Yes. Bearing in mind what is in the 9th schedule, which when we get to, we'll have to fix.
Yes.
Because there's some things that don't, are not clear, and things like fees and stuff that are general things that you will put in regs will go here.
Okay.
Yeah.
All right.
So, yes, members. So it is for the entire 213 to be redrafted, having regards to the 9th schedule.
But the committee should just take a decision on 4. Regulations made under this section shall be subject to affirmative resolution. So
Yes.
the committee needs to take a decision on that approach.
Okay. Members,
Sorry, what is your advice in terms of that?
ask Member Brown.
It is my understanding that the senators always want to be fully involved in the discussions of and to exercise their powers as lawmakers. So normally if you say regulations are subject to affirmative resolution of the House, it would exclude the senators, which I know is
So
not
it
a
have to be
popular
both
position.
houses.
So this means it's both houses.
Both
of
houses,
Parliament.
right.
The other option is not to have parliamentary oversight, which I am not in favor of, where you would just say that the minister has the power to make regulations, and it would mean it's done by order. That does not find favor with the Attorney General's chambers. We do value and think that there is great value in the parliamentary oversight. There are a few laws, though, that will indicate that some regulations shouldn't come to Parliament when they are of a purely technical nature. But regulations made under this law, we would support it coming to Parliament and having parliamentary
No,
oversight.
we always like when it come to Parliament so that we can see it and review it. And there's a particular senator that I know that sits where Ms. Shelley Ann Thompson is sitting that usually likes to find debate around these.
So Sergeant, you are recommending that we retain 14? Yes, 213-4.
213-4.
Right.
That would be our recommendation.
Yes, members. I know you agree, Member Brown.
Chairman, with 4 of the 6 committee members present, being members of a certain chamber, we want to make it clear
Very well.
that affirmative resolution is the only route that we would support.
Very
You're
well.
speaking for yourself.
Very well. So we may now proceed to 214. Ministry?
I think AG had a commentary 5.
Yes, but I thought you have accepted that.
Oh, so it's to be deleted?
Yes.
Okay.
Yes. 214?
All right. 214 addresses codes of practice developed under the Act.
Proceed, Ministry.
Okay. So we're asking for this provision to be redrafted to specify the minister is required to lay codes of practice developed under this Act or revisions of said codes on the table of each House of Parliament. These codes and any revisions to the code are developed by a process that involves consultation with organizations which represent employers and organizations which represent workers. The codes of practice and revisions of same are to be published in the Gazette. But just to make the intent clear, some of these codes will be specific to industries, so it includes the tripartite, yes, but it will have to go wider in terms of consultation with other stakeholder interests.
Yes, 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 CPC.
The codes of practice, I was thinking for legislation of this kind, the code of practice would relate to the activity of the PBCU. But I'm asking, is it related to the activity or is it related to the employer-employee situation? If that is the case, what are you speaking of guidelines? For instance, we have a MOCA code of practice, which deals with the code of practice of MOCA officers. Yeah, it is law. It's their regulations under the MOCA Act. I am thinking here that what we really want to establish is code of practice of a particular industry. And in that case, is there anywhere in the bill that where we have actually stated that it is mandatory to do so? Right? And if that is the case, then we can then say that it must be submitted to the ministry or to the authority for approval. But I think 214 as drafted isn't clear as to what particular type of activity you would want to have in this code of practice.
Ministry, could you, before you member again, you would have heard Mrs. Seeley Brown. Mr. Mahon.
So these codes of practices will be guidelines. And I know you raised a question about it being industry specific, but some of these will go across industries. Let me give you an example. For example, confined spaces. You may have a confined space in a factory, or you could have a confined space as at a construction site. So
that means that the ministry, you're going to develop these codes?
Well, the codes will be developed, as we said, with consultation from persons from the different industries, representatives from worker organizations, employers.
But it would be something developed by the ministry's experts or by the industry experts?
Right.
When we had looked at the functions of the authority, we had given the codes of practice, the development to the authority. The minister is playing an approval role in relation to it. So if we go back to the body corporate and what we had said, this was a function of the authority to develop these codes because they, of course, would have the technical expertise there within the authority.
Chair.
Yes,
on the issue of codes.
Yes.
I have a couple of comments. But let's take a specific code, for example. Currently existing is a code between employers, unions, and government in relationship to people with HIV. That's a code adopted, Mr. One, from the ILO, the work the ILO has done. That's one such code that certainly would be adopted, could be adopted and become a code under this legislation. So it's not just about confined space and so forth. We may have codes relating to COVID or any other disease that may come. So that I am happy that we are moving away from a code to the existence of multiple codes. The approval process for those codes, I see you're saying consultation, but and that is what produced, for example, the HIV code. But Chairman, I have in mind, and I see the ministries thinking about it, but hasn't come down. There's another code, for example, that relates to employer-employee relationship, the Labor Relations Code of Jamaica. It's not being proposed to have a single ASH code, but multiple codes. But each of these codes, should they go through the process that the Labor Relations Code went through, presented to both houses of Parliament and sign off on, don't say it. That's one of the issues that we need to look at. For example, so that these codes, and I see somewhere it says whether or not a contravention of these code by itself, in other words, they accept the wording of the labor relations code and the approach. And by the way, that has been signed up by all the courts in the country. So I am not yet decided whether or not we should go that process, but it's a process that is open to us. Right? So I'd love to hear the policy thinking in respect to codes.
Yes, but the information here, Member Brown, says that the codes and or the revision of said codes to be tabled in each House of Parliament. Yes, you're not satisfied with that?
It says that, but I don't know if that's a policy
well,
that is being adopted. So this is what I'm saying. I'm not sure if that is the policy. I saw my friend from the parliamentary council office was about to say, I'm not going there, I don't like that route.
Well, I will hear from CPC momentarily, but I want to hear from you, Member Gill. Yes.
I will yield to CPC.
I understand.
And then I will present my comments.
I'm still not clear as to what is it exactly, what is it exactly we are codifying. Because to my mind, correct me if I'm misguided, if you are establishing codes of practice for a particular type of industry, shouldn't that code be established by the industry and then submitted to the authority for approval rather than the other way around?
I think the consultation, Mrs. Seeley Brown, would involve the... Yes.
It just says the minister may approve a code of practice. It doesn't say, you understand? Who prepares it, and yeah.
So here's my take on it, Chair. And I like the language that has moved from may to is required. Shall being the operative. Now, it's codes of practice. So it expresses in my mind that there may be codes of specific industries through a process of consultation that involves the tripartite approach, inclusive of the authority. Because I am not going to leave it to an industry developing a code that has its scope and interest of just that particular industry without the consultation of those who every day represent workers. And when this particular code was being developed, and I know, David, one you don't particularly like or is attracted to this particular code, that especially when it don't suit you. But it is important, Chair, to have these respective codes go through a process of consultation that invites the comments, the recommendations, and the suggestion from the specific industries. What I'm seeing now, coming out of COVID-19 is a myriad of protocols being established without the required consultation. And some of them are running across borders and boundaries, some of them even overlapping what we are doing here today, when you look at some of the protocols that has been established. So the important thing is to have the consultation, but to have it in a tripartite nature, involving the employers, the state, the authority in this case by extension, and those representing workers, and not an approach that the industry singularly develops a code that it feels and deems fit for the approval of the minister. So it has to be a consultative approach.
Member Skeffrey? Yes, that's what gets you. Go first. Yes, you're right.
So it will be preparation by the industry, the specific industry, after consultation or with consultation and recommendations from the authority and all of the other stakeholders, and then final approval by the authority.
I wouldn't want it to be prepared by the particular industry. I would want the consultation of the tripartite approach to take place where it is inclusive of the respective stakeholders, so that there's agreement at that stage before it's presented. So you may have a situation where the industry prepares it, and when it's submitted, Jamaica Employers Federation is not in agreement with it. I'm not going to say it's us not in agreement with it. So you'd want the involvement, the direct consultation in the first instance before it goes before. And I'm suggesting that these codes go before the Labor Advisory Committee, at least, where there's that direct tripartite mechanism that has already been established.
And Chair,
Yes.
Chair, my ever-present other partite that should be included is the health professionals at that stage of developing the codes from the very basal levels.
Mr. Chair.
Before? Just one last thing, because again, when this was being developed, there would have been consultations taking place, an engagement taking place. And this is also, in the development of this code, it is going to require that level of interface outside of just those, the tripartite, but even to involve the Ministry of Health and any other body that we might want to touch base with to get their feedback and recommendation.
Yeah, Mr. Chair, I support the process of consultation to derive the respective codes. But to say here the minister is required to lay codes of practice developed under this act or revision of said codes on the table in each House of Parliament. What do you hope to achieve? Because you can table a document in the House of Parliament and you do not debate it. You just table it for information. So parliamentarians have no input to participate in a debate. So do you table it for debate or you table it for information? What's the objective?
Put another way, may I just strengthen Senator Skeffrey's point? The 75 legislation, which developed the little red book that Cavan held up all the way. Can you hold up that red book again? It looks blue to you. We know how we say it.
You have to understand, Senator Brown only sees one color.
Yeah, it is a little. It is a little. If you notice, David has left the chamber. So anyway, yes. The point I'm making here, Chair, that labor relations code had the blessing of both houses of Parliament, and as one arbitrator described it, with the support of all the courts up to the Privy Council, it is as near law as possible without being law. Is the ministry wanting to give these codes that status? Because that's important that we know that. In which case, Senator Skeffrey's point is that it can't just be tabled. It must get the approval of both houses of Parliament. And so and I shared that view about how we develop it. I think one other thing the ministry may be able to help us with, Chair, and it may help the drafters, and so Mrs. Celia Brown would just hear this for me. The view that it is industry that is going to drive the codes, and I mean that in a general way, it's not codes for industry. There may be codes for industry, but there may be broader codes having to do with, take COVID. Instead of just beseeching people, The minister may want to bring a code saying, and sanitation, mask wearing in parliament, and everywhere else. So that you may want to put these things in code which have to do with safety. And so that we might find that the codes go beyond confined area, height, depth, and those things. Those may be part of what forms code, but the code could be broad. And as I've said, the HIV is one, and this afternoon we will hear people coming here speaking to that as well, about that code. In that case, O'Neill is a President Grant. It's a grey book that is well distributed. I don't know if the ministry have a copy here today to show that ILO code on HIV, which was developed with the support of government employers and workers from almost 200 countries. Well, all that would be figured in health, but that code has been developed. And so we must see the codes in that broad sense and not specific to, yeah.
Member Gill, yes.
Chair, let me just reinforce a point that I think is key. And Member Skeffrey raised it, and Member Brown enhanced it. It was never viewed in my mind that this code, once developed, is just going to be merely tabled before this Parliament. But there is going to be that second look by especially the upper house for review before it is passed. And also, any future amendment to that code would have to go through that same process. So, whatever is going to be crafted as the intent in this particular clause must outline explicitly that process from now. We talk about consultation and approval by ministry, but coming to Parliament is not just to table for information's sake, but it must go through the rigor again by the Parliament before passage.
Mr. Simmons.
Thank you, Mr. Chair. I just want to be clear, a question from the ministry. The way I'm reading this act, aren't these codes going to be fairly technical codes?
Yes, ministry, your time.
There's so much response. Okay. In the first instance, we believe that the authority, well, the government, has to drive the process of developing the codes. I'm trying to get to everything. Because if you leave it up to the parties to start the process, then the codes may never be developed. But we understand that you'd have to have broad-based consultation. But the government has to drive the development of the codes to make sure that there actually are codes. But of course, consult with all relevant parties. So that's...
Someone has to lead it in terms of the process. And that the authority in this case is the state. That involves the consultative mechanism. Because the state have to drive this, you know. You have to take charge of it. And that is our expectation.
Mrs. Bellingham, proceed.
Yes. So we did have, or it was our intent, because unlike the Labor Relations Code, it will be multiple codes. So we had taken the approach of laying as opposed to debating, but we're open to revisiting with our principals because it won't be one code. So we'd have to come with, if it's 20 we develop, for example, we'd have to be coming with 20 to go through a process of debating.
Yes, Sergeant.
Are the codes expected to have force of law or not?
Well, what?
force of law? Will the code have
Are the codes to have force of law, or are they to just be guidelines? Because that would determine the process.
So it will be the intent, as you notice that we have redrafted to be nearer to the labor relations code and the weight it has. It's not a penalty if you look. 215. The clause deleted and replaced the provisions that specify that a failure on the part of any person to observe the provisions of said codes of practice in and of itself will not render him or her liable to any proceedings before a court or tribunal. However, a court or tribunal is required to take into account any provisions of such code which is relevant to the matter being heard. So, similar to the labor relations code, is going to be as good as law as you can get.
Okay, so, well, you see, I read this and I didn't understand. So you're saying there are guidelines?
No.
But they don't have force of law. It's either they have force of law or they don't. So there are guidelines.
Well, sorry, Chair. My understanding is at 215 on page 3 of the ministry's document that they want to replicate the Labor Relations Code, which, as they say, a breach by itself has no consequence. But before a tribunal or the court or the tribunal shall take into account provisions of that. And that is what led.
But what does that mean, to take it into account? Because if you don't adhere to it, you can't be prosecuted. So I don't understand what it means.
Privy Council in the flour mill judgment explain what take into account means, right? And it flows from what Clinton Davis wrote at the IDT, that this code, while not being law, is as near to law as is possible without being law. And it therefore gives the tribe, it says the tribunal must enforce the provision of it. That's what it says, essentially.
The LRIDA refers to the code?
3-4
and says, so it's the same procedure that you want. No, it's the same process you want for these codes?
That's where I'd want, that would be my recommendation of any code.
Mrs. Bennett Campbell.
To be accurate then, there's one thing I should add, because the Labor Relations Code, I believe, is more than laid. Laid before the House. Yeah, so the Labor Relations Code is debated before.
Yes. Mrs. Seeley Brown, I wish to hear from you. You will have to help the guy. Yes.
Yeah, because
Yes. Mrs. Seeley Brown, I'll hear from you, Sergeant, and Mr. Simmons.
Yes. I reserve my comment.
Mr. Simmons, yes.
Yes, Mr. Chair. I wasn't sure if I see the intent behind what the ministry is seeking to do, but I think my earlier query, and I think it's following on what Mrs. Seeley Brown was trying to get at, is that I do think that these codes of practice conceivably can be as near as law as possible. I was trying to find the original or the policy intent behind, for example, the issuing of an improvement notice, because I do believe they linked the improvement notice to the code of practice. And in as much as you can be enforced on an improvement notice, it means that the code of practice is going to be something that the industry will have to follow. The issuing of an improvement notice, as I see it, is going to be something which requires someone with technical competence, which is why I asked the question. I do believe these codes of practice will be very technical in nature. So I don't know to what extent these codes of practice can be debated by persons who do not necessarily possess the technical competence to speak to these issues. I'm not saying it can't be laid before the House and debated by individuals, but you will require, as I see, technical guidance, which is why I think Mrs. Seeley Brown was repeating over and over where is the involvement of the industry. I do think it is more than just persons from employers, workers, and government, right? And I want to know, or certainly I foresee, that in the development of these codes of practice, you're going to need someone with technical knowledge to develop these codes of practice. And I want to know if it is that it's possible to incorporate that into the development of these codes of practice into the bill.
Yes, Soldier.
I don't think you have to delay too much on that, because normally when you have, there are other laws that talk about consultation process when you're developing codes, where you say, so you can identify specific people, and you can also leave it more general to give the minister the power to consult other bodies. But as it relates to the whole issue of what's in, I've looked at the LRIDA section 3.4. I suspect there was a reason the court had to rule on it, or at least expound on it, because it's still not a very clear provision. And the thing is, if we're going forward, I would say we shouldn't necessarily just use that approach, because it would probably mean then that it goes back to our court for our court to discuss it. I would prefer, because I'm not that familiar with these issues, so I will look at if you give us some time, we can look at the Flour Mills decision. We can look to see what the court's guidance was, because I would not want us to just replicate a provision where we had to, so perhaps maybe the guidance from the court could assist us in terms of crafting the provision in a certain way. Because reading this provision, 3.4, I would prefer us to just get some time, Chairman, just to refer to the guidance of the court and then look back at the provision, rather than we put something in that someone could again challenge, because that is not really ideal.
Mrs. Celia Brown.
Sorry, SG. Also, Chair, I have also seen provisions where if you breach a particular provision of a code, you can be held liable. So, well, we don't know. Is it that in truth?
It's not our intent.
Even if you're speaking about safety standards and stuff? No?
No, we will have the regulations. We're giving practical guidance through these. Are giving practical guidance through the codes.
Chair, I hear the technical people saying they want some time to look at the implication of the wording in 3.4 of the LRIDA, and they'd love to see how the courts have looked at it. And because that is now settled, the issue of the code is long settled as to how it is treated. And as we suggest, the Flour Mill case would be one that went all the way, one of the few that went all the way to the Privy Council. And it has been settled, and
so we're going to defer clauses to 14 and 15. Yes?
Mrs. Bennett Campbell, is it then that you're going to have regulations dealing with some of these issues separate and apart from codes of practice or guidelines?
Mike.
The point of a code of practice normally when we use it, because we're also using it for disabilities, is to break down in simpler language how you can practically deal with certain matters. So it's not using the legal language of our regulations. So it's a guide with not the legal language that you have in the regulations. So I guess the point we're debating is the weight to put to it. But it's not supposed to be in that legal language.
So we are speaking about guidelines, Chair, and not a code of practice. Mm-hmm. Which is something. No, but a code of practice is a totally different thing.
Yeah, that's a matter of form.
Chair.
Yes.
We are at a very important part of history, in that this is a very crucial piece of legislation, and this particular clause is one of the most important part of this piece of legislation. And wherever we know what our objectives are, especially the trade unions on this side and the advocates on this side. And I'm going to inform myself as to what was the intent in 76. In 76. Yeah? 1976, of the intent of those who developed this. Because I'm sure it would have been the same intent that we are promoting today, whatever those are, right? But at the end of the day, you see what is outlined in 2015 2 is very important in terms of how we treat this particular clause in the future. And I think it was Mr. Simmons who spoke about it being technical. There are areas that are going to be technical, but those would have to be guided by the experts in the particular industries. And what I wouldn't want the committee to today detain itself with is those industries. Because industries will be here today, and there may be a new industry tomorrow that may have to be included. So I won't be guided by that at this time.
Yes, very well. So I believe that Sergeant has asked for some time so that the AG's chambers can address its mind to what is intended by the ministry. So we, in respect of 214 and 215 ministry, we will revert to this clause at a later date. These clauses at a later date. So you may proceed to 216, 17, or 18. If there are any comments or issues, I think the AG series clause 217.
217.
Yes, Minister.
Sorry, Chair, it was just clause 217, it was just to link it to whatever the decision the committee makes with respect to the appointed day. That's the only thing we were advising.
Sorry, so just to explain,
Yes.
the review provision says it's 5 years after the appointed day, but it depends on what your appointed day is. Because if you have different dates bringing the whole act into effect, you may have to say the first. Right.
Yeah, but you agree, the first. After
Right.
the first appointed day.
But I mean, it's just that I don't think the committee has taken a decision on that provision in terms of how we are bringing the act into
Yes,
effect.
the ministry,
right.
the ministry
so I'm
is
just
to
saying
come back.
whenever you take that decision, this
Yes.
will be linked to it. That's all.
Okay.
You know, I got the impression that we had bought into the view that there may be multiple appointed days.
I think so,
I thought
but
we had taken your point.
I think so, but I believe that the ministry, in a proper way, is to come back to the committee. Yes.
So it's a ministry, because I think the committee had agreed that there ought to be multiple appointed days. And in that case, we also accept that the review should take place.
Let's take guidance from Ms. Bennett Campbell. I think yes.
We actually did come back, but there was no decision taken because after one of those long breaks, we had come back in that first sitting to say we had reconsidered our position, but we were looking at other matters that day and no decision was taken. But in transitional, I am dealing with that issue in transitional, which is coming next.
Okay, very well.
So we can get the decision we need.
Yes. So we have noted what the ministry, AGC has indicated in 217. So we may now proceed to part 15.
Do we agree on 17?
Okay. So we go back to 218. But remember, Brown, you're asking whether or not we. I think what AGC is indicating is by virtue of the staggered implementation. There may
we
be
insert the word first.
Yes.
After the first appointed day.
Let's agree on that.
The only issue is if you tie it to the first, the first date may only to bring into effect very basic administrative matters and not necessarily the meat of the matter. And I would suggest that you would want to have a good enough period, and then you could have a big lapse. So I'm thinking of Road Traffic Act. You could have a big lapse between the beginning, the first implementation, first part of the implementation, and the rest of it. And you want to be able to review it, you really need to have some amount of time in operation, because we have seen where we have come to a joint select and the act has not really been used and utilized to get very good feedback. Maybe you want to suggest the last day.
I would suggest the last day. Okay.
Chairman.
Yes.
Yeah, I think first up, I think the first day should be where we target, because if the process is such that even after the first day it takes so long, that in and of itself is something that needs to be reviewed, and that needs to be.
For instance, Chair,
yes, Mrs. Seeley-Brown,
look at the Integrity Commission Act. That has been in effect for how many years now? But we have only started the administrative process, and it's almost up for review. What are we reviewing? When we have not seen the act in operation. See, even if you don't want to wait until the last date, you could say when particular parts of the act have been in operation. If you think that waiting until the last date, appointed date, is probably too long. But sometimes it takes a while to have the administrative structure actually up and running, and then there's time for review. So there's really nothing.
I think the significance of this and the fact that we're dealing with the lives of workers and the health of workers and the environment in which they work in varying industries, I think most definitely the first date.
Chairman, I want to 1,000% support my colleague, Senator Langmore, on this. This would have wasted all the time we spend here if this act is rushed into implementation by the ministry. We're repealing the Factory Act by this, So there will be no protection, not even the 1941 legislation will be there to protect workers when we pass this legislation. So it can't. We have the ministry need to get this going quickly. So I would say, just in response, for example, to Ms. Seeley-Brown, the Integrity Commission Act is the worst example. That has called for review long ago. In fact, many different leaders have said it should be reviewed. Can't wait for it to, the flaws are clear, are very clear. So with this one, the review process may force us to implement it. And that is why the review process must come from the first appointed day. And in other words, as parliamentarians, we will be failing our duty if we spend all this time over these many years. And again, I repeat, this legislation has been around from the half-a-tree clock was a wristwatch. That's how long. The half-a-tree clock has grown from being a wristwatch. So this is how long this has been about. So we can't spend a couple more years trying to get it done. It has to be done with speed.
Yeah. We have to be careful too. Bearing in mind what Member Brown said, when we are repealing things under this act. Right. Yes, right. So if it means that we need to save regs, we need to all right. Just
Mr. Simmons, you.
Yeah, I was just saying maybe the concerns of Member Brown and Member Longmore have provided the answer that Mrs. Seeley-Brown was alluding to. Maybe the review should be when the provision repealing the Factories Act actually comes into force. That could be the operative date.
Yes, Ministry, any comment? Having heard the deliberations.
Yes. Huh? Oh. Yes, we have heard the comments. Our only concern with the first appointed day is that the point of a JSC is to look at the provisions that are practically in play. Because now we're looking at a law in theory, basically. So it's having come into effect with the main provisions. The committee then will be seeing what are the weaknesses practically. So that was my only concern with the first appointed day. Because we know we would have tried to establish the authority first, for example, so that it can come in and do some work. So that was my concern. The point of the second JSC is to look at the act that has been implemented and what are the weaknesses.
We know we're going to have a staggering system.
Yes.
But over what time period do we hope to have all the staggering completed? Yeah, but we must have, the ministry must have an idea. Because we don't want to have a bill, we initiate the first phase, and our 10 years, the bill is not being effective.
Well, that's why I had, in response to Member Brown, I did say that the ministry is to come back.
No, but that is
the committee.
I don't know where the thought process is now. Yeah. We are discussing a review, so at least they could share what the thought process is for the staggering.
Yeah,
so you don't have you're not staggering forever.
The transitional, I believe, the transitional provisions that we are going to may help us. But
no, Mr. Chair, why I asking?
Yes.
Remember, the ministry didn't come here with an intent to have a staggering system, you know. But the AC chamber proposed, if my memory correct. So your intention was to have everything go at once, full speed ahead. No, that's my understanding. That's
originally.
Correct. I know the Sonjel spoke about staggering and so on. But I didn't say any provision. There's no provision here for staggering. These are appointment date in the bill. But the suggestion came and we have accepted it in good faith. So if you were planning to go all at once initially, then you would have had a proposed review date. Now accepting the proposal to stagger, it can't be indefinite now. Because you are ready to go instantly.
Can I just, and I know the committee doesn't like the comments I made earlier about this provision, but I have seen how practically it has failed. So the Disabilities Act of 2014, which is not yet in effect in 2020, Section 48 said it was to be reviewed no later than 3 years. That should have been from the, well, no, this said from the appointed, after the appointed day. So the issue is, because of this kind of provision, they have not been able to bring the Disabilities Act into force for that and other reasons. Because once you know you bring it in, then time starts to run. I'm just pointing it out.
Yeah, but let me tell you, the reality is, in this country, legislation takes too long. Sometimes for good reasons, but take too long.
All right, well then let me give you a different example then. The anti-gang law, which was brought into effect and reviewed. But by the time it came for review, it had not really been used. It had not really been used, and there it created a problem again, because we had one matter that had gone to the courts, and at the time when we started the review, there was just one before the courts. There was no decision even from the courts on that. And so the problem was, when we went through, yes, there are some amendments that are going to come to Parliament, but because the Act has not really been utilized, so I'm just saying, don't dismiss what I've said.
I'm not dismissing it.
I'm just pointing it out. Just pointing it out.
But you see, again, and I'm glad you raised those examples, because it informs us as to the mistakes that have been made. And it also dictates how we can possibly treat this piece of legislation. The concept of it, wasn't to go in the phase basis initially. But when we started to discuss and see how extensive and expansive the legislation in terms of its objectives, and the number of changes in approach and policy direction that would have been developed during these consultations here, we came up with that intent. Now, one of the things in my mind that is important is for us to establish from the onset, Chair, what are the possible timelines as to these phased implementation, so that we can at least hold that down in the legislation. And then you're going to have a situation where for each of them we evaluate how they are working, and so that calls for the review. It may also call for a revision of those that are slated to come because they become irrelevant because of situations. Take COVID-19. COVID-19 has changed so many things and informed us. So, Chair, I would recommend strongly that there's an established timeline with the phased intention. And I don't know if the ministry can identify what those timelines can possibly be, so that we can agree on them from now through this committee, so that it's not a situation, Chair, where we pass a piece of legislation, we dance hippie-porray about it, and then we have challenges with the implementation after that.
Yes, Member Brown.
I share Senator Gale's view. The reality is the 84 parliamentarians regularly get beat upon by sections of the society for tardiness in bringing legislation through. I'll never forget former Senator Arthur Williams constantly making the plea that we need to strengthen the staff in CPC, for example, so that they are able to produce more legislation in a shorter time. It's not their fault. We, it would say, haven't given them the resources. But in this case, this is a piece of legislation that both sides of the parliamentary divide are at one that needs to be passed. I would expect that the Ministry of Labour and Social Security, who is in charge of this legislation, would be given the resources to fast track it. I want to make the point also, Chairman, without taking tails out of school. It is my understanding, and you could tell me if I'm right or wrong, that it is the policy of this government to fast track the passage, and I go beyond passage, the implementation of this legislation. I glean that elsewhere, and I'd be happy if there's some confirmation that this is the desire. And you will find from, well, I can't say opposition because there's no opposition to this at all. There's one. We're all at one. A commitment from the parliamentarians to get this before the parliament for passage and implementation. If that is so, then, and we've seen a lot of things we have put off. We put off this penalty, and that because wait and see how it works, the review. This is urgent. It is a shame and disgrace that we still function under a piece of legislation dealing with occupation, health and safety that has its origin in 1941 and some amendment along the way. Mr. Chairman, there are friends of mine who were in prison some time ago. Well, at least one guy come out of prison that day. When he went in, cell phone wasn't in existence. It's the changes that have taken place in society in 10 years is such that we can't keep Belize, Trinidad, Guyana, everybody have something looking like this. And we don't have any. We are still stuck in 41 and 61, 1941 and 61. Where's the pride? Where's the desire to make life better for the workers of the country?
Yes. Member Brown, I'll just briefly say that yes, it is a priority of the government that this legislation be fast-tracked. Not just the passage of the legislation, but certainly the implementation. And I guess the frequency of these meetings will send the clearest signal as to the priority that the government places on the legislation. Ministry, I will just want you to comment on the phased implementation, because you'd have heard the comments of Member Secrecy, which I believe is supported by most, if not all, of the members in terms of the definitive timeline for implementations for the different sectors. Yes. Yes, Mrs. Campbell.
Yes, Minister. What happened is that we learned from our mistake with a previous legislation where we tried to put everything into effect. But for example, we needed the body corporate under that act to be established to help with some of the work that needed to be done. So in this legislation, having been guided by the Solicitor General, we looked at it and said, let's learn from our mistakes. If we wait for the whole act to come into effect, and we can't even bring in the body corporate until then it's going to be slower, because then the ministry is still doing all the work without the support of the body corporate. So that is why we were going for the phased implementation, having learned from our previous mistakes. The point of the matter is, when we came here at first, the appointed day would not have been declared until all those provisions had been done. But if we do it in this phased way, so we can at least bring in the authority to help with some of the work that needs to be done, then it would mean that we will get to implementation quicker than the ministry still trying to do all of the work. And if you would notice, with transitional arrangements, we are not actually taking out all the provisions of the Factories Act until protection is in place, which is why its transitional arrangements are important. Because we are trying to keep the protection that we have now in place until the relevant provisions come in to effect. So it is not our intent to leave the country without any kind of protection. In terms of speaking to the exact times, it would be hard for us to sit down here and do that now, because that's why we needed the authority also to come in and practically be able to guide the minister. So even if we come with a projection, no, it's a projection of the Ministry of Labour, not the body corporate, and not benefiting from the body corporate coming into effect and giving guidance to the minister to say, okay, let's bring in this now, let's look at this. So for me, it would be a challenge. We can always go and sit back, but the ministry would have to be able to work without the body corporate to say which provisions are coming in at what date, and it's hard to do that at this stage.
Chair, I respect the view. I've listened, but my only fear is that by the time we are ready to implement this law, it becomes obsolete.
Yes.
This thing has been on the table over 10 years. Over. And then, even for rush and pass it, what I'm hearing, there is no... What I want, and I don't, not necessarily today, but before this committee life would have come to an end, even a timeline. You must have something to work towards. You don't have to achieve it, you know. They know the technicalities. How long would it take the authority, assuming the effective date to start comes for the authority to come into place X time? How long would it take it to up and run and start the work? So at least we have some idea as to when. I'm sure when the very first intent for the bill, you had some timeline. The first minister that started this work had some timeline. I want it in 2 years. I see some smiles. It never happened, but you must have some timeline to work towards.
Yes.
I don't expect it today, in all fairness. But I believe we're getting closer to getting the bill passed. We are closer than we were.
Yes.
But having passed the bill is to implement it. That's what will be important. Yes. So you must have some timeline. Staggering system, yes, but a timeline for full implementation. Within 3 years after effective date, 5 years, 10 years, some timeline.
Yes.
When a business establishes a strategic plan, it has some precise targeted objectives. And so I never anticipate that we're going to define any timelines. But there are some areas of this piece of legislation that requires some stated timelines and commitments. I don't even know when this agency is going to be established.
Exactly.
But I would not have wanted this committee and this technical team to go through all this awesome work. And there is nothing that when we're asked the question, so when this is going to happen, when that is going to happen, we can't comment on it. And I want to lay the concern today. There has to be some commitments. I don't want, Chairman, I don't have no grandkids yet, you know. And it's outside, that is outside of my control, but I would want to ensure that even when the grandkids are working, they are protected.
Well, what I will say is that the ministry definitely will come back to the committee in respect of this matter of the staggered implementation. The concerns have been heard.
Just closing for me. Just listen.
Yes.
Before coming here today,
yes,
I was always hopeful. That's why every Monday morning I'm here early.
Yes.
But leaving here, the hope is diminishing.
No, Member Skeffel. No, Member Skeffel.
Because I believe why I gave the commitment, my
you
personal...
have indicated that...
No, why I gave my personal time. Because I know the importance of this bill both for the workers and the employers. But I don't want to pass this bill. Committee finish work.
Yes.
The technical team move quickly to do the drafting. You come back here and we go through the review. And it take to Parliament, and after the third reading, they mash up.
Yes, but what...
in both houses of Parliament.
What the ministry
said... No, we're not here.
Yes.
And then, nothing.
Yes.
What I see this probably going to be even longer than the Disability Act, after 4 or 5 years. I'm serious.
Well, the ministry has definitely learned from the situation of the Disabilities Act. But in respect of this bill, however, member, the concerns you have raised, we are in agreement with you to the extent that, one, we do not have the information here as a ministry today, but the commitment is that at a later time, before the work of this committee is finished, the ministry will revert to the committee on the matter of this staggered implementation and the request that you have asked for. Okay. Very well.
You saying that is a little comfort in my mind now, Chair.
So we will defer also, Member Brown, the amendment to 217 that is being contemplated, whether it is the review will come whether after the first appointed date or the last, as some persons are suggesting. So we will proceed to, I think, Mrs. Seeley Brown, you had a question or a concern with clause 218? Yes. And let us proceed, yes.
Just to delete subclause 2. There's no need to say.
218.2, you are proposing a deletion.
218.2.
218.2, yes. All right, Ministry, any comments, members, any comments in that regard?
No, sir. 218 has some policy issues to be resolved. The 10th schedule addresses the form of the tribunal. And I'm not sure if we have, I don't know if we are settled on the form of the tribunal, for example. Where does it? Sorry?
Member Brown, the 10th schedule deals with the amendments to other enactments that would have...
Including the LRD.
Oh, that's what you mean. But
that's what I mean.
We're not going with the LRD again.
See it on page 193.
Yeah, but we're not going with...
That's one of the second act you're amending.
But we are not going with the LRD we're establishing. Aren't we establishing our own tribunal? No, only for some
In
purposes.
fact,
Yes.
there are two
Yes,
acts
no,
being.
no. Yes, yes.
There are two
Yes,
acts
yes.
being
Yeah.
amended.
I stand corrected, Chair. I stand corrected.
Yeah. All right. So
It has been clarified, Member Brown. So we'll defer it until a point. Okay. As one, it is okay. Standard rules of.
Something that's in the Interpretation Act. 218.2 should be deleted.
Okay.
So all you need is 218.1, which would now be 218.
Okay, Member Brown. Are you clear on that now?
is 218.1.
Oh, very
where
well.
It deals with the 10th schedule.
We were.
But we're coming back to that, you're saying?
Yes, man. When we look at the schedules, I'm sure we may have to come back to that clause. So, Ministry, what is before us is the deletion of 218.2, subclause 2. Any comment? Mrs. Benny Campbell? Yes.
Yes. We revert in relation to 218.1 because we have made some amendments in the face of the bill that will actually affect how the 10th schedule is set up.
Yes,
so
but we're talking about 218.2.
Yes, we agreed.
Okay, very well. That's all we're interested in at this point. Some members, we agree. 218.2 will be deleted. Yes. Ministry, part 5.
This is transitional arrangements. We were trying to simplify the provisions as contained in the bill in terms of trying to set out the policy intent. So we would have retained 219.1 and 2. And then we wanted to introduce on the policy paper now, legal proceedings or claims commenced under the Factories Act before the appointed day, which are not completed before said day, are to continue after appointed day as if this act had not been enacted. Nothing in this section is to affect any civil or criminal liability incurred under the Factories Act before the appointed day. And in terms of the staggered arrangement now, we were trying to introduce C. Provisions of the Factories Act are treated as remaining in force until the corresponding provision is this act, provisions of the Factories Act are to be treated as remaining in force until the corresponding provision in this act, if any, has been brought into operation. This amendment is being sought as the Ministry has decided to accept the recommendation that different provisions of the act should be brought into force on a phased basis. So that the drafter can help us, it's just we're trying to keep in the protection under the Factories Act in place until the relevant provision under this act is brought into force.
So in other words, you're having, in order to ensure protection, you're maintaining some sort of a hybrid approach.
Yes, because...
Comments? Soldier?
The Interpretation Act has these kind of provisions. What we have done sometimes is just imported some of them into laws. Every time you see a transitional provision, it wasn't created out of the air. It's coming from Section 25 of the Interpretation Act. I would suggest that what the ministry does is just have a look at, even if you didn't put anything in, Section 25 of the Interpretation Act applies when you repeal something. And remember now, if you haven't already repealed the provision, the other one is going to persist. No, but it's 25, the effect I'm talking about.
What you're in fact saying, Chairman,
Yeah, but
since I was still on the floor,
yes.
What you're in fact saying is that...
So what I'm saying is what is represented in the bill is garbled.
Is what?
Garbled. And what is in the, it is. No, what is in the bill is very difficult to read and doesn't make some of it is, it doesn't even accord with our law. I'm just saying, just use Section 25 of the Interpretation Act. We don't even need those provisions. You know, I'm always one for, there is a reason we have things in the Interpretation Act. It's because we don't need to repeat them. But we have this new thing where we keep repeating things, and then the problem is we repeat it in a way, we repeat things in a way that don't then accord with the I'm sorry, I'm getting a little bit, this is,
yes.
it's not that, it's just that So I would say give us some time, we can come with something that's way more straightforward. That would accord with the principles of law, generally.
Let me just ask, Chair.
Yes,
So what I'm understanding is,
Member Gill, yes?
yeah, no, I want the Soldier.
Member Flynn, I have been doing so many deep breathing sessions just to read clause 219, and I still don't understand some of what it is trying to do. Yeah, I agree with what SJ is saying. Let us go through the interpretation section, see what we would like to apply, and only provide for things that we would like to do that are not there. But once it's there, we really shouldn't be repeating it.
Sorry, but there's a bigger issue that was not even addressed in the bill, the staff. So no, that is something. The staff.
Well, and it's both now.
That is what is really most important, and it's not even in the bill.
But it wasn't today. Remember, it was a department.
Right.
Yes.
So that is what those.
And they are to have come back to us.
Right. So the point is, those are the really important provisions that need to be in the bill, because unlike these other provisions where you have the Interpretation Act that applies, there's no other law to cover the staff. You will have to put in provisions to deal with any transitional arrangements you have for the staff. That is what is crucial. Not so much what is being addressed here, because the Interpretation Act deals with these matters.
Chairman.
Yes, Member Brown.
This is sounding like Manu versus Bournemouth over the weekend. And so I am hearing that transitional arrangement section 219 to 224 need to be redrafted. 224.
So, Mrs. Seeley Brown, you will.
To take into account Interpretation Act, the staffing issue, and all of those transitional matters. And that I'm seeing a call for deleting 220 to 221, bill to make provision for transitional arrangement. In other words, it's not ready for us in the committee, is what I'm discerning. And if that is so, I would move for all of this to be reviewed by the committee, by the ministry, and come back to us. 224. Yeah, which is the last one.
Ministry, in respect of the staffing, I see at point 3 here you have made
We had presented the staffing in the body corporate policy.
yes.
We had presented the staffing there, so we thought that would have informed here. We were sent back to do more work on it. But we agree with 219 to 224. We were trying to redraft because we realized it's not very clear
Very
at
well.
all.
Very well.
So we'll be guided by the drafters and the Solicitor General because we know
Okay.
it's not clear.
Very well. Yes.
From early in the game, and even at this last minute, why do we have this gap between the drafters and those who initiating the bill? Why can't that gap be closed?
In my
So
view,
that
it has.
So that what we have here today, I mean, the word, when I use Manu versus Beaumont, it was a way of not using the word slaughter. Slaughter, yeah, because it strikes me that these provisions are being slaughtered by the technical teams. I know, that's why I use the analogy of Manu versus Bournemouth.
Liverpool. Yes, so I think what is clear is that this part needs to be redrafted. So I'm sure there will be discussions between the ministry and AGC and yes, CPC. The
To
part.
what area?
The part.
The entire part?
Yes.
Okay.
Yes. So once that is done, then the ministry definitely will come back before the committee. So, since we have deferred part 15, I believe this is a convenient time for...
Take that, Chairman, because when we come back, we have guests,
Yes.
I believe. But we still have a few minutes, and I wonder if in the 6 or so minutes we have,
Yes.
we want to adopt an approach
Yes.
to the schedules.
Okay, very well. Very well. Mrs. Seeley Brown, I think you will have to assist us here. Member Brown is asking that an approach be developed and agreed on in terms of how we will treat with the schedules. Okay, yes.
I was just discussing that. Yeah, I'll let Mrs. Bennett Campbell speak to what we just discussed. Yeah.
Very well.
Yes, because the schedules also depends on other areas that we have to fix within the bill. And because the draft had asked for the opportunity to be able to start drafting, I think it is best that we go to the interpretation, and then she had asked for the body corporate to be finalized in terms of the changes we're told to make so that she can start drafting. And then we would approach, in terms of the matters we're coming back with at the ministry, we'll approach it clause by clause in terms of parts, so we can finish a part for her to be still drafted and we can issue instructions.
But sorry, that question before,
Yes.
if I may, the stakeholders' comments,
Yes.
the non-legal.
Yes. I believe...
Well, I shouldn't even say non-legal. That's not true because I think you even had attorneys coming. So,
Yes.
so the other stakeholders' comments, because that may impact on
other...
Well, yes, I think it could impact the definitions. I mean, I remember that there was one person, Mr. Gammon, who came to raise issues about like the domestic help and all of that. That would impact definition of PCBU, employee, worker, all of that. And then even JPS, again, some of their comments could also impact on the interpretation of some of the provisions that we are using and would help to guide. I'm just saying that we can't ignore that right now. No, I mean in the process, if we're outlining, going to the definitions, I think we actually need to review what the other stakeholders said before you can get to the definitions, not the other way around.
Very well. Yes.
What I would hope that we can do, though, Chair, is as fast as I draft the parts, before we get into anything else, when we come on Mondays, we can just review that, take that as our to-do, as our offered on our to-do list, and yes, and then move on. So we don't have to. I don't want us to have the entire draft to read or to go through when we finish. I think we should go through it in stages, yes, and critique.
Very well.
As we go.
Very well. I think that
Chairman, I believe my question was about the schedules.
Yes,
and
but
the approach to the
I
schedules.
think, Member Brown, what has been communicated is that the drafters, they have asked that we put them to work in the shortest possible time. And in order for them to go to work, the definitions will have to be finalized, and aspects of the body corporate that the ministry is to come back to the committee on, they will have to do that too. But what Solgen is saying is that the stakeholders' comments are yet to be reviewed by this committee. So we need to do that in order to finalize the definition along with the establishment of the body corporate.
Let me ask it another way.
Yes.
This committee is not going today or before we hear from the stakeholders' comments address the issues of the 10 schedules.
The 10 schedules, yes.
The 10 schedules.
Yes.
Sir?
Yes, all the schedules. All the schedules.
Not 10?
Yes.
Right, including the 10. I think what the ministry...
10 schedules.
The 10.
You understand?
Yes. No,
so
but
let
what
me
I'm
use a
saying is-
three-letter word. Instead of T-E, and let me use A-L-L. All of them.
Right, but I'm just saying I support the approach of the ministry and of CPC in that we should try and deal with the definitions and other matters before we get to any of the schedules. But I was just interjecting before even any of that to do the stakeholders first. But yes, I think it may be a little counterproductive to try and do one or two of those schedules, even though they may seem to be independent. We have all learned by now, that everything is interconnected with this bill. It's one of those kind of bills where everything is related and connected.
Chair, I just want to be clear. We're going to proceed from having finished the 224 clauses. We're going to now go to look at the stakeholders' view while the drafting team seek to do some other.
I think we have to complete the stakeholder review and then we move to the definition section, complete the section in respect of the authority, the body corporate, and that would put the drafters to work while we do other work as a committee, which will include the review of the schedules. Yes.
It's beginning to look like Christmas.
No. Mrs. Benny Campbell, yes.
Minister, as you have spoken, I cannot say what I was going to say.
Okay, very well. But I believe, Member Brown, the stakeholder comments in terms of what we would have discussed as a committee and the concerns we would have raised, where the stakeholder comment touches on concern, something that we would have deliberated on, we will move on. Stakeholder, yes.
As I commented, I took into account the matrix with the stakeholders' views. So it's kind of artificial, but I don't mind.
I believe we have, but out of an abundance of caution, we will certainly look at it. Mrs. Benning-Campbell, you wish to say something?
Minister, I still just want to put it on the table because the stakeholders have a lot of comments on the definition section, which we could have looked at the same time. Because what means that, all right, when you go through all the stakeholder comments, some things are no longer relevant because we have changed policy.
Okay.
So we're going to take our time going.
I suspect. Yes.
Mr. Chairman, I'm optimistic. I think it'll be quick because, as Senator says, we have ventilated quite a bit of what the stakeholders, JPS and other stakeholders actually brought to the fore, where we actually debated those in the bill, going through clause by clause. I'm very optimistic.
Yes, but remember we have the visitors today, yes. So, what happened is that we had invited two teams here, but there's only one coming. We had invited them for two. So we will decide how we take them at that time. Or we'll take that team when we get back after lunch. But this is a convenient time, so we will now break. We will take them, but we have the stakeholders' comments, so we have to decide among ourselves whether we start that today. Since we believe that substantially we would have covered it, we may very well have completed it or can complete it today. Yes.
We have to be sure.
That's it.
Yeah, we have to be sure. We can't just assume that we would have covered it. We just want to be sure for the records itself.
Yes, and that is why we will be looking at it after.
The last one.
We started that one. We went through it now.
So we will be getting copies for everybody after lunch. Yes. Yes, we will. Yes. You have to get it. Yes. Almost certain members, Kevin, but out of an abundance of caution. It was very early in the day. That's where we started. Yes, and then we move into, yes, so you're, yes, man, and we will. Yes. I am of that view too. I'm sure the ministry also. Yes.
But we
Mrs.
Yes,
Mrs.
but we
Benke.
have changed some of our positions since that document. Remember,
So we will look at it, members, after the presentation of seropositives, and then we take it from there.
Sorry, did you comment on every single stakeholder?
For this one.
Oh, she's saying no, so you can't use that one. Yeah, all right. So it doesn't. So don't circulate that one then. Don't recirculate it.
All right.
No.
So did we break for? So we now adjourn for lunch, members. We resume at 2 p.m. promptly. Very well.